Hello, everyone, and welcome to Thursday Talks with Chug. Each week, we cover pressing topics that matter to you and your business. My name is Arianna Gonzalez, tuning in from the San Diego office. Please join me in welcoming Senior Partner and Attorney Mishita Jethi from our Edison, New Jersey office. Hi there, Mishita, and welcome.
Hi, Arianna. Very good to be with you. Thank you for having me.
Thank you so much for being here. For today's topic, we will be discussing H-1B Cap Exempt petitions. Before we begin, just a quick disclaimer, this conversation is for informational purposes only. It does not create an attorney-client relationship. So if you have questions, please comment them below or email us anytime at info@tube.com so we can help you out. Let's get right into it, Mishita. Can you tell us what are H-1B Cap Exempt case petitions and how do they differ from the regular H-1B lottery process?
Of course, that's a great question. So H-1B cap petitions can be filed at any time during the year, unlike the H-1B cap subject petitions, which can only be filed during a fixed time that the USCIS informs beforehand during the lottery time. The other important distinction is that the H-1B cap exempt petitions are not subject to any numerical limitations. As most people might already know, H-1B cap subject petitions have a numerical limitation, about 65,000 cases for the regular petitions and about 20,000 cases for advanced degree exemption cases. So unlike those, H-1B cap exempt petitions do not have any numerical limit.
Oh, wow, that's really good to know. So, which types of organizations are eligible to file H-1B capped exempt petitions, and how can they benefit from this status?
Absolutely. So the most common H-1B cap exempt employers could either be institutions of higher education. These are institutions which are either a public or a nonprofit institution. They admit students for graduate school, and they are authorized within their state to provide program which is beyond the secondary education. And they are accredited by a nationally recognized accrediting agency or association. The other kind of employers that can file H-1B cap exempt petitions could be nonprofit entities that are related or affiliated with institutions of higher education. For the entities to be considered related or affiliated, the two entities, that is the institution of higher education and the nonprofit, should either have shared ownership or control. The nonprofit should be operated by the higher education institution. The nonprofit should be attached to the higher education institution as a member, a branch, a cooperative, and there should be a formal written agreement between the nonprofit and the Institute of Higher Learning for permissive activities. The next kind of employers that could file H-1B cap exempt petitions could be nonprofit research organizations or government research organizations. But I think there's a very important discussion here to be had that although most people believe that H-1B workers are considered exempt only if they're employed directly or indirectly by a qualifying entity, such as the ones that we just discussed, it's equally important to remember that the employee does not necessarily need to be working directly for the cap exempt entity. And this distinction is important because a lot of time, H-1B cap exempt employment roles could be those where the employee will spend majority of his or her work performing the job duties at a qualifying entity, even if the actual employer is not cap exempt. Some examples of these cases can be where a commercial or a for-profit entity has affiliations or agreements with a qualifying entity where the work has to be performed at the qualifying entity and the job duties directly or indirectly further the mission of the qualifying entity.
Wow, really great information there. Thanks for sharing all of that with us. So, are there any advantages or benefits to having an employee on a cap exempt petition? And if so, what are those advantages and benefits of having an employee on a cap exempt position?
Definitely. I think the biggest benefit for those who can be employed at cap exempt institutions or can be sponsored through a cap exempt petition is that they won't be subject to the annual lottery. As many of you might know, that USCI has recently conducted the second round of lottery this year. And while a lot of people may have get picked, a lot of prospective employees do not have their registrations picked up. And then they wonder what are the other avenues of employment available to them if they do not get picked in the lottery. So this is definitely one of them. If those employees or potential employees find an employment through a cap exempt employer, they will not be subject to the numerical limitation. There's also flexibility in hiring because, as we discussed earlier, these petitions can be filed at any point of time during the year. Cap subject petitions typically have a start date of 1st of October in a fiscal year, whereas cap exempt petitions can be filed at any time, and those employees can start work at any time. Finally, cap subject employment is for a fixed period. It's for 6 years once someone gets picked in a lottery, unless they have met certain milestones in their green card process. Whereas a cap exempt petition, they can continue to be filed even beyond those 6 years. And another great advantage is that for those who are employed at cap exempt institutions or have employment through a cap exempt petition, they can also have concurrent employment with a cap subject employer. It's very important to understand and remember, though, that the cap subject employment is tied intricately to the cap exempt petition. So if the cap exempt petition comes to an end, or if that position ends or is terminated, then the cap subject employment will also have to come to an end.
Wow, really important information there. If you are watching this and have any questions regarding this process, please reach out to us. We'd love to connect you with Mishita so we can help you out. So, Mishita, in order, if somebody, for example, wants to prevent a gap in employment, can a cap exempt H-1B petition be filed immediately for an employee who was not selected in the lottery?
Yes, they could be, that can be filed immediately, but I would caution again that employers should plan this process well in advance. As we know that H-1B petitions take some time, some lead time to be filed in. In particular, there is a 7-day requirement for the LCA to be certified, which is required for any H-1B petition. The other important point to consider is that if the prospective employee or foreign national is changing status from another different visa category, they need the H-1B petition to actually be approved before they can start working on the H-1B status. And although premium processing, the option of premium processing is available to the employers, they should discuss this with the immigration attorneys in advance so that, one, they don't find themselves suddenly with an unexpected gap in work authorization for their foreign nationals. And B, sometimes the foreign nationals might want to extend their employment in a particular visa category for as long as they're able to before switching to the H-1B. So it is possible, certainly, but definitely speak with your trusted immigration attorney or reach out to us so that this can be discussed and planned well in advance.
Absolutely, that's great advice. I think you touched on this earlier, but I do want to confirm. So can an employee work for both a cap exempt and a cap subject employer at the same time under an H-1B cap exempt petition?
Yes. So as long as an employee has one cap exempt petition approved, the employee can get another cap subject employer to file a concurrent H-1B for them. Again, it's important to consult with an immigration attorney to strategize this process because the employment at the cap subject employer would be dependent on the employee maintaining the cap exempt employment. Sometimes the cap exempt employment may have certain conditions, that may make it either a little difficult or maybe, it might require a little bit more strategizing to have a cap subject petition be filed concurrently. So it can be done theoretically, We just have to see, how those facts pan out. And finally, as we talked about earlier, if the cap exempt employment ends or if it's terminated, it will also impact the cap subject employment. So anyone who files a cap subject employment petition for a foreign national relying on the fact that he also has a cap exempt employment petition approved should, keep checking with them that they're still maintaining the cap exempt employment, because if that comes to an end, the cap subject petition will also have to be either revoked or that employment would have to come to an end.
Got it. That's really good to know. So is there a maximum number of H-1B cap exempt petitions that an employer can file within a year, or no?
No, so there are no numerical limitations on the H-1B capped exempt petitions that an employer can file within a year. However, I would, again say that the normal caveats would always apply, that anytime an employer thinks about filing an H-1B petition for any prospective employee, they should be able to show that the position actually exists, right? That job is available, that position is available. So if the idea is simply that, let's just file a bunch of petitions and see what gets approved, and then we'll fill those positions in. Sometimes USCIS might, take, they might consider that to be fishy. So while there are no numerical limitations, I would always say that the employers should not, they should refrain from filing any non-frivolous petitions.
Okay, really good to know. So what is the process for transitioning an employee from a cap subject H-1B role to a cap exempt position within the same organization?
So if the same organization is, if it's eligible to file a cap exempt position, if it's able to file a cap exempt position to retain an employee, what they should do is that while the employee stays on the cap exempt H-1B petition, they should concurrently keep submitting their name in the H-1B lottery, which is, conducted annually. It's possible that at some point the employee's registration will be selected in the lottery. And when that happens, if the employer still wants to continue having the employee work for them, but transition them out of the cap exempt position, then they can file that H-1B petition for them once their registration gets picked up. And after that second petition is approved, then the employee can transition to the cap subject status. And this process can also be used by another employer. So let's say if the foreign national is working for one company, which is able to file a cap exempt petition for them, or for an institution of higher learning or one of the other qualifying entities. And during that time, any other potential employer could keep submitting this foreign national's name in the lottery. And if and when they get picked, if the intention again is to continue employing them or to transition them to this new prospective employer, they could file the cap subject petition for them.
Really great information there. Again, if you are watching this and have questions, please reach out to us. We'd love to be your helping hand through this process. So, Mishita, can an employee who is on a cap exempt H-1B transfer to a cap subject employer without going through the lottery again?
No, I think unless the employee has either been selected in the lottery or they continue to maintain their employment at a cap exempt institution or an employer who can file a cap exempt petition for them, they will not be able to sort of run away from the lottery, if that's the question. It is important to understand that while any employee who has never been selected in the lottery can move between different cap subject employers, they will always need to have that anchor petition with a cap exempt employer. The only way to move out of that restriction would be to get picked in the lottery at least once. Once they get picked in the lottery again, then they will not need to have this anchor petition with the H-1B cap exempt employer. Then they can move between cap subject employers, just like any other foreign national who's been picked in the lottery. But everyone needs to get picked in the lottery at least once.
Okay, that's great information. So, what about one question we get quite often? If an employee is not selected in the H-1B lottery, can they remain in the US while awaiting approval for a cap exempt position? What happens in this case?
Yes, that's a great question, and definitely one that we encounter very often. So this will depend a little bit on what is the visa category on which the foreign national is currently on. There are certain categories such as, F1 when they're students, where it may be possible for them to continue staying in the United States while the H-1B cap exempt petition is filed and approved. But once again, discussing this with an immigration attorney is important because they will be able to navigate questions not just about remaining in the US, but another question that goes hand in hand with this is, what about my work authorization? Not only can I continue to stay in the US, can I also continue to work? And in some situations, there just may have to be, some sort of a gap in work authorization, again, depending on what visa category they currently are. But in most cases, I think with good planning and a little bit of timely filing of petitions, I think potential employees and other employees who did not get picked in the H-1B lottery should be able to continue staying in the US while their H-1B cap exempt petition is getting approved.
Okay, really good to know. I do want to touch on expedited processing. How long does it typically take for an H-1B cap exempt petition to be processed? And are there options for expedited processing?
Definitely. So the regular processing time, it may vary depending on, the caseloads of the service centers. There are times, especially when the service centers have a lot of cases, when during like peak cases, where it may take between 4 and 6 months for the H-1B cap exempt petitions to be approved. But there's definitely an option of expediting the processing time by opting for a premium processing request. The employer would have to pay a fee associated with the premium processing, which at the moment is about $2,800. And it's worth noting that we should keep an eye on this fee because sometimes these fees go up and down without much notice. So at any time when an employer is considering filing these H-1B cap exempt petition, they would do well to just consult with their attorney and see what is the current premium processing fee, and if it's worth it for them to pay that that fee for expedited processing. Sometimes it may not even be necessary. Like I said, if the employers plan a little bit ahead in time, it's also possible that they may have those 4 to 6 months to spare while the foreign national is probably on some other visa category or has work authorization through some other visa status.
Got it. Great information there. So we do get a lot of people that come to us with denials of H-1B caps and they need help. So what are some common mistakes that lead to denials of H-1B cap petitions that we want to shed light on, and how can employers avoid them?
Sure. This is a great question. So, as we discussed earlier, right, not every employer might be able to file a cap exempt petition. Maybe they're not institutions of higher knowledge. Maybe they're not nonprofits associated or affiliated with these institutions of higher learning. Maybe they're, not qualified in certain way. So but at the same time, the reverse is also true. Sometimes the employers may actually qualify to file the H-1B cap exempt petition, but they may not be, they may not necessarily know very well that they are. So I think for the employers, one of the big mistakes or one of the issues that they might face is they may not be able to adequately show whether or not they're cap exempt, which means they may not be able to sufficiently provide documentary evidence that they are an institution of higher learning or that they are a nonprofit associated with an institution of higher learning. sometimes employers may not be able to demonstrate that the job duties which are proposed to be performed by these foreign national are duties that are directly and predominantly meant to further the essential purpose, mission, and objectives of the qualifying institutions. A third category of risk factors that we see or mistakes that we see commonly are employers who themselves are not qualifying entities or qualifying institutions, but they have some affiliation or an agreement with a qualifying institution, but that agreement or affiliation may not be correctly documented. They may not have sufficient proof to show that they are affiliated to a cap exempt institution. Another common issue that we've seen, which leads to RFEs or sometimes even denials, is that employers who are affiliated to these qualifying entities are unable to show how their prospective employee will be placed directly or will be spending majority of his or her time at these qualifying institutions to do the work. So sometimes very small mistakes or very minor things get overlooked and petitions get denied. So therefore, it's extremely important that any employer who is considering filing cap exempt petitions, discuss with their attorneys. A lot of times we see employers didn't even know that they could qualify for filing an H-1B cap exempt petition. And when we discuss with them, whether, discussing on their line of work, what are some of the products they build, what are some of the services they provide, who are their target audience. In discussing all of that, it suddenly appears that they may actually have working relationships with certain qualifying entities, and voila, they might just be eligible for H-1B cap exempt petitions.
Those are some really great insights, Mishita. I appreciate you going through that with us and, sharing, what usually people do make mistakes on and what to really look out for when you're going through this process. So how can an employee on a cap exempt H-1B visa relocate to another location within the same organization without affecting their visa status?
That's a great question. Theoretically, yes, they can, the employer can file an amendment to relocate them to another position. But, the theme in all of this discussion that we've had so far, as you may have already noticed, is that the cap exempt employer has to continuously prove that the job duties are such that are in furtherance of, the mission of the qualifying entity, and that majority of the time of the foreign national is being spent at that particular qualifying entity. So if the cap exempt institutions are able to prove that they have another location which meets all of the requirements for the cap exempt position, then they could file an amendment and have the foreign national be relocated there. But if it's, for example, if it's a university, right, which is hiring a foreign national on an H-1B cap exempt position, and let's say they don't have another campus, right? Let's say they don't have another work location, then that might be a little harder for them because it'll be hard to show that the foreign national is spending majority of their time with that qualifying institution. But there are a lot of universities and nonprofits which are affiliated with institutions of higher learnings that may have, satellite campuses or other locations. So again, it gets very fact specific. In some situations, it may be possible.
Okay, got it. I do want to touch on costs a little bit. Are there additional costs or legal considerations for employers filing H-1B cap exempt petitions compared to regular H-1B petitions?
No, the filing fees and the costs, the fees that needs to be paid to the USCIS, it remains the same as an H-1B cap subject petition. So, the filing fee, the acquire fee, the fraud prevention fee, premium processing, assuming that is what the employers would like to expedite the petition with. So all of the normal fee that is paid in the H-1B cap subject petitions would also apply to the H-1B cap exempt petitions.
That's great. I think employers will love to hear that, no additional fees required. So how can organizational changes such as restructuring or mergers, for example, impact an employee's cap exempt H-1B status? Does it impact it at all? What does that look like?
Absolutely. I think that's a great question and something that, employers should always keep in mind, even regardless of H-1B cap exempt petition, is that H-1B petitions are always filed by, a specific petitioner, like a specific employer. So anytime there is a reorganization, restructuring, any mergers, acquisitions, if that impacts the corporate structure of the petitioner, of the employing petitioner, then they can have potential impacts on the H-1B cap exempt petitions. For example, just at the top of our head, if the qualifying institution loses its status as an institution of higher learning, let's say, due to this corporate restructure or merger, if the institution of higher learning loses that status, or if the nonprofit that is affiliated with the institution of higher learning loses its affiliation or gets absorbed by another nonprofit, which is no longer affiliated by this institution of higher learning, or if a particular company had certain agreements with an institution of higher learning or with a qualifying entity, and that company had filed the H-1B cap exempt petition for a foreign national, but this company now gets acquired by another company, and that company no longer renews the affiliation or the agreement, then all of those petitions which were depending on these affiliations with the qualifying entities, those H-1B petitions would be in jeopardy, because then the qualifying petitioner would lose its status as a cap exempt employer. So therefore, if there are any mergers or acquisitions or corporate restructurings that are, in the near future of employers, they would do well to do not just a regular audit, but also an immigration audit of all of their employees, particularly if they hire foreign national population. Even if it's a small population, it's always a good idea to do that immigration audit to see whether this restructuring could have any impact on the employment, because you never want a situation where after all of the merger or after the restructuring has happened, you suddenly realize that the work authorization of a few of your employees has unexpectedly been terminated.
Several great points there. Thank you for sharing that with us. We are almost out of time, but I do want to ask you one more question. Can
Yes.
an employee on a cap exempt H-1B petition eventually apply for a green card? And how does that process work?
Sure. I think this question may require, a whole other Chug Live session, but to give you a very brief answer, yes, a cap exempt employer could also potentially start the green card process for their employee, very similar to any other regular employment-based green card petition. So they would have to go through the labor certification process and, then file the I-140 petition. Depending on the kind of position that we're talking about, there could be certain changes. For example, if the H-1B cap exempt petition is filed for a university professor or a similar position, then, the employer could potentially be able to deviate from the regular employment green card process. There are things like, they could potentially bypass the labor certification process. They could potentially qualify for a special handling of the perm case. So those become slightly nuanced questions. But I don't think that the H-1B cap exempt petition by itself would stop an employer from sponsoring a foreign national for the green card. That they could certainly do it. There could be just ways around it, and there could be certain different ways of doing it, but it can always be done.
Wonderful insights. Thank you so much, Mishita, for your time and taking the time and energy to share all of this wonderful information and all of these great insights with us. That is all we have time for today. So this brings us to the end of our conversation. Thank you so much, everyone, for joining us today. A special thank you to you, Mishita, for your time and wonderful insights. To stay up to date, please subscribe and follow us on Facebook, LinkedIn, and YouTube. If you have any questions or suggestions, please feel free to send us an email at info@troop.com anytime. And make sure to join us back here next week for more pressing topics that truly matter to you and your business. Until next time, stay safe and take care, everyone. Thank you again for joining us. Thank you.